Good morning, good afternoon, good evening, wherever you're listening to this recording from. My name is Emilia Onyema. I'm a professor here at SOAS University of London. And for those of you who do not know what SOAS stands for, it's the School of Oriental and African Studies. We're part of the University of London. So today I'm going to be talking about a recent publication, a research, an empirical data gathering research, which we just concluded and published at the end of December 2025. And the title of the research is The Role and Participation of African Women in Arbitration. What I want to share with you is on what the method. The first thing is why. Why are we doing this research? So we understand what the gap is. And then the methodology, how we did the research, and then our findings. So the why question. And the why question arises from the fact that from anecdotal evidence, we do not have a lot of African women involved as arbitrators, so sitting as arbitrators in international arbitration. The women who are very well known from the continent are, you can count them with over two hands or one hand. So that was the key driver. And the question we had was, who exactly is doing arbitrations? Who is sitting as arbitrator? Which African women are sitting as arbitrator, to enable us know whether there are those who actually do this work and have relevant expertise. And so that's the primary driver that led to the research. The question then becomes, why is this even important? This is important as part of the inclusive agenda that we have currently in international arbitration, the need to ensure that as many as have the relevant expertise get the opportunity to fully participate within the community. And so the next question we then had to figure out is, how do we conduct this research? We normally, every 2 years, publish our Arbitration in Africa data gathering research report on various topics. And the idea with that is to include African voices in the discourses that we have within international arbitration. And so this is an off-cycle research that we decided to do. How we did this, so the methodology we adopted was the usual methodology we adopt, which is we have an online questionnaire which we circulate and over 6 weeks or more, and we collate data. We then, for this particular research, we also included a focus group discussion. So we had 3 virtual focus group discussions to enable us tease out the findings from the online project, online data gathering, the responses we received online. So what were the key findings? The key findings is that we had 90 respondents from 19 African countries. The usual suspects, Nigeria, South Africa, Kenya, were there. But the one country that was a surprise was from Zambia. Now, I've been to Zambia. I've done trainings for counsel in Zambia, so I know that there are lots of arbitration enthusiasts, but I didn't realize that there were that many Zambian female arbitrators who actively practice in the field. So that was an interesting finding. It wouldn't be surprising for you to note that 88% of the respondents are lawyers, and quite a number of them also act as counsel. And that relates back to where their appointments come from. For most of them, their appointments come via the parties, understandably, because they also act as counsel. And 76% of the respondents hold postgraduate degrees, which is an interesting finding, which needs a little bit more interrogation, because of course you get people always asking, do I need a master's degree? Do I need to do a postgrad studies to be able to participate in arbitration, either as counsel or as arbitrator? And it's an interesting finding that 76% of these women hold postgraduate degrees. 48% of the respondents are educated in the global north, which is also interesting, which has two dimensions of the interest. The first one is actually an economic and status point. The question being, do you have to be able to afford to do a postgrad or first degree in the global northern countries, which has cost implications and can itself be a way of excluding other women from participating within the community. The other point about it then becomes, I think we can all understand why these women are also involved, because when you are educated in the global north, such as my own university, you'd get to meet people from all over the world. And in that way, you build networks and you build connections that would translate at some point to possible appointments or co-counseling work. And so that is really an interesting finding. The other point, one of our other findings is that 62% of the respondents publish professional materials. And that just validates one of the talking points on how people can enter into arbitration. We generally would say it's good that people are known professionally. And one way of getting known is through speaking at conferences, is through publication, and they publish various, the publication is in various formats. So you have those who do blogs, case summaries, commentaries, academic publication, but the important point is publishing professional materials. 76% of the respondents speak or moderate at panels at conferences. I just mentioned that. It's all part of that getting known as well. 83% of the respondents belong to an arbitration-focused association. And most of them found that really, really valuable. And it wouldn't be a surprise to those of you who are conversant with arbitration on the African continent that 79% of these are members of the Chartered Institute of Arbitrators. The other bit of the findings is on the arbitrator experience of our respondents. 44% of them act as both mediator and arbitrator, while 40% sit only as arbitrator. And in teasing out why, the response we got was depends on what appointments they get. And the other thing I already mentioned, 54% of the respondents also act as counsel, and that correlates with where appointments come from. We know that 83% of them have sat in at least one arbitration, and 6% of those have experience in 40 plus cases, which is really, really interesting. We also then know that 81% of our respondents have conducted an arbitration from the first preliminary meeting to the close of the proceedings, and 69% of them have actually written and published a reasoned award. That is super important because, in my opinion, I think it's important to appoint somebody who has at least written one award, and that is really important. And then that goes back to who appoints those women. Various people, the parties, 80% of them have been appointed by the parties. Remember, they act as counsel as well, so that access is there. And 36% of them have been appointed by co-arbitrators, again, linking back to their primary professions. 64% of them have been appointed by appointing authority or arbitration institutions. And another interesting finding is that 21% of them have been appointed by their national courts in default appointments. And really interesting, women supporting women, 56% of them have been nominated or appointed by another female arbitrator. So I think these are really great findings. We now have data in the public domain, empirical data that we can rely on the expertise of African women in arbitration. So there's absolutely no reason why many more African women cannot be appointed onto tribunals to determine cases as arbitrators. We're hopeful that people would find the data useful and that they would further interrogate the data and work with the data. Thank you very much.